This talk considers how the need for social care services is assessed by a social services department or a children's services department as an eligible, or we would sometimes say an assessed need. It looks at the legal position in England and Wales, and it addresses the needs of disabled adults, disabled children, as well as older people who have needs. In a separate talk, Care and Support Planning, we'll consider how these needs, once they've been identified as eligible, are translated into services in the community. For example, a care assistant to provide help getting somebody up in the morning, or adaptations or fixtures in the home, or support to participate in community activities, or help to go in a care home, or direct payments to the disabled person or their families. Now, this talk is divided into 7 separate sections. And those are an overview and definitions, the background to the duty to assess, what I would call the assessment question, which we'll see is really to ask the question, what if? The eligibility criteria, how carers assessments fit into the scheme of things, some common problems that are encountered with assessments, and then the final section, part 7, will be further resources and materials. These are follow-up materials for in-depth study, and they include details of the statutes, because the law is different in England and Wales, and it's slightly different for adults and for children. In this section, we're going to consider some definitions and some basic principles that apply for assessments of need. Definitions we need to look at include what is a disabled person, how that's defined, what is a presenting need, what is an assessed or an ineligible need, what is an unmet need, and what do we mean by outcomes, what do we mean by needs, and what do we mean by services. The first important point is that the duty to assess somebody's needs is triggered not by the person having to ask for an assessment, but by the local authority being aware that the person has needs, what the law calls the appearance of a need. So once it's aware that there is somebody to whom it has duties and that person has needs, then technically it must assess without any request. People who are eligible to be assessed are very widely defined. They include elderly, ill and disabled people. And what is important is that law, the definition of a disabled person is widely drawn. This includes not only sort of classic disabilities, but the phrasing includes a mental disorder, a mental impairment of any kind. Now that will include somebody who has a mental illness, of course, or a learning disability or a personality disorder. But it will also include people who sometimes fall between the cracks in terms of social services response. People with a high IQ, but autism, what we would call high-functioning autism, or people with hyperactive disorders or attention deficit disorders. These people are all at law considered to be disabled people and therefore are all entitled to have an assessment. Whether, of course, their needs will be considered eligible is a separate question. We then have to consider the difference between what we would call a presenting need and an eligible need. A presenting need is a need that the disabled person or their family or somebody closely associated with them tells the local authority about and identifies as important for that person. That becomes an eligible or an assessed need when the local authority makes a decision that it is a need that requires a response from that authority. Once the local authority decides something is an eligible need, then it's under a legal duty to meet that need. If the local authority decides that the need isn't eligible, then it's what we would call an unmet need. It's one that isn't, it's a need, it's a presenting need, but one that's not considered eligible. And we'll look at that in greater detail in a short while. It's also important to consider the difference between what we would call services and needs. It's generally said that somebody has a need for a care home, or they have a need for a stair lift, or they have a need for a day centre. Now, technically, that's not correct at law. I don't have a need for a day centre, but I may have a need to be active in the community, to have a social life. And one of the ways, of course, of meeting that need is to go to a day centre, but it might be a need that could be met by me going into further education or getting a job or going to bingo. I have a need to access the toilet, and that might require me to have a stair lift, but a stair lift is a service that helps me meet a need. And so we need to separate out what are needs and what are services. Local authorities tend to talk about outcomes. What would somebody like to happen in their life? So I would like to have interaction with my local community. That's an outcome. And then we would identify ways that we could make that happen. Local authorities have very wide powers to meet the needs of people, their aspirations and their outcomes. Unfortunately, the law's not always politically correct, and I'm a lawyer, so if I sometimes slip into saying that somebody has a need for services, I hope you'll forgive me. Whilst details of the relevant acts and legal materials are contained in Part 7 in the resources section at the end of this talk, there's one act, one statute that we do need to look at briefly. It's the key underpinning statute. It's the National Assistance Act 1948. This act did something incredibly important. Section 1 of that act abolished the poor law. And the poor law came to an end on the 5th of July 1948. And with the abolition of the poor law, we got rid of the workhouses and we got rid of some of the very harsh and unpleasant aspects of the system that had preceded the Second World War. In fact, a system that had lasted for 350 years. And one of those provisions was a thing called the liable family rule. Under the poor law, children were responsible for the care of their parents, and parents were responsible for the care of their children, even their adult children, and siblings were responsible for their other siblings. Effectively, care was a family or charitable obligation, and only the state took control when somebody was completely destitute and could prove that they had no family that were prepared to look after them. Now, that was abolished in 1948. That's a very important factor. Adults do not have to care for other adults, even if they're married to them. And carers' assessments, which we're going to look at later on in this talk, must start with the carer, the unpaid carer, being advised that there is no assumption they're willing or able to provide or continue to provide care. Parents of disabled children do have responsibilities for their children's care, but that is significantly limited in this country as well, because parents of disabled children have a right to work, like all parents. They have a right to an ordinary life, and the state is responsible for the additional burdens they bear because their child has a disability. They have a right to undergo education or training, and they have a right not to be made ill or their well-being to be affected because of their caring responsibilities. Very many carers of disabled children and of adults have significant mental health, anxiety, depression, acute stress problems. And the law says that those things should be ameliorated, should be addressed by social services. An assessment is basically a very simple question, and the question is, what if? What if we, the local authority, don't provide any help for this disabled person, this older person? What will happen? If the answer is significant harm, then the state has got responsibilities to act. It's got responsibilities not only under the social care legislation, but also the human rights legislation. The more serious the harm that would follow if somebody isn't provided with support, the more compelling will be the obligation on the local authority to provide a response, to provide care and support arrangements. Now, there is a duty on social services to undertake one of these assessments, and that has to be undertaken by somebody authorised by the local authority and somebody with the skills to do it. People who are being assessed have a right to a face-to-face assessment. They have a right to somebody visiting their home and seeing them, and they have a right to that within a reasonable timescale, and we'll look at that issue later. It's very important that the assessment does take place in a setting of the disabled person's choosing. 75% of all the information we take in is visual. We need the social services representative to come and see and to hear and to smell and to use all their senses to take into account the person's situation. At law, the duty to make this decision requires that the decision maker consider all the relevant information. So we're going to give that assessor letters from family and friends, from neighbours, from priests, from doctors, from nurses, all the things that are relevant. And all those documents, all that evidence will be saying that if the particular need that is being identified is not met, then the person being assessed will suffer significant harm, and we would be, in those letters, giving indications of what that harm is likely to be. It might not be immediate harm, but it could be harm that will occur over the weeks or months ahead if that need is not addressed. The assessor then has to take all that relevant information back and to decide which of those needs, those presenting needs that she or he have heard, are eligible needs. Having gathered information about a person's presenting needs, spoken to all the relevant individuals, the social services officer will have to make a decision about which of those presenting needs are eligible or assessed needs. She or he will have regard to what are known as eligibility criteria that local authorities publish. These eligibility criteria look at what would happen if a need wasn't met. The more serious the consequences to somebody's well-being, the more likely that they will be considered to be eligible needs. When we talk about well-being, we're talking about not just physical well-being, somebody suffering physical harm. We're talking about social well-being, their interaction with the community, risks to their independence, that they may no longer be able to live independently, risks to their mental health well-being, their emotional well-being, and so on. And as I say, the greater the risks of harm to somebody's well-being, the more compelling will be the argument that the local authority must consider that to be an eligible need. So the social worker will consider the eligibility criteria, and he or she will then have to say these are eligible needs and these are needs that are not eligible. These are needs we don't need to meet. And at the end of this process, therefore, we should have a list of assessed needs, eligible needs, and a list of unmet needs, needs that don't need to be met. And it's important that we get a copy of that document, because we may wish to challenge it. We may wish to say, well, no, you say this need is not important, but it is, and we're going to make a complaint, we're going to make representations unless you identify this need as an eligible need. Here, for example, is a doctor saying that if this person doesn't have, a doctor's report saying that if this person doesn't have this particular support, she may become depressed or she may become isolated. The need doesn't have to be one that would cause harm immediately. It may be something that would happen over a matter of time. So, for example, if somebody doesn't go out and interact with the community, then that might not be a problem for a week. But if that happens for a prolonged period, then they'll become isolated withdrawn, perhaps depressed, and so one would identify that as an eligible need. The key point about this process is that once a need has been assigned the label of an eligible need or an assessed need, then the local authority is under a legal duty to meet that need. And it's a legal duty that cannot take into account resources. The need just must be met. Now, in a separate and following talk, we'll look at how the need could be met, and the local authority can meet needs many ways, but the need must be met. It's a non-resource dependent duty, as we say at law. If during the assessment of a disabled person, an elderly person, a disabled child or adult, it becomes clear that that person has an unpaid carer, then that carer has a right to an assessment themselves. These are referred to as carers' assessments. This will apply whether the carer is an adult or a child. We have a concept called young carers, which are people that are under 18 who are providing substantial care for their parents or very frequently a disabled sibling. Carers have a right to be assessed. Just as with disabled people, older people, they have a right to have an assessment which is face-to-face, and they have a right to have that assessment in private so that they can sometimes say things that they wouldn't perhaps want the disabled or older person for whom they care to know about. Of course, there's no reason why carers' assessments shouldn't take place in the presence of the person being assessed, but sometimes it's best that these be dealt with separately. Carers' assessments should always start with the carer being advised, being reminded that they do not have to provide or continue to provide care. No assumptions are going to be made on that behalf. Although parents of disabled children, that's people under 18, have responsibilities towards their child. They have responsibilities towards their child, but the additional responsibilities that come about through disability are things that must be considered in the carers' assessment process. Parent carers have a right to work. They have a right to ordinary lives like everybody else. And so these are issues that must be addressed. And the carers' assessment, as I say, first of all, looks at the issue of whether the carer is willing or able to provide or continue to provide care. If they're adults caring for adults, then they don't have to do that. The second issue that must be considered in carers' assessments is the impact that caring is having on the person's health and well-being. Very many carers suffer acute stress, anxiety, depression. Many of them are clinically depressed. And many of them suffer from other difficulties like lifting injuries and so forth. So that aspect must be considered. Is it really feasible for the carer to continue providing care because of that impact? And the final issue that we look at in carers' assessments is how their caring responsibilities are impacting on their other activities, their involvement in work or education or training or leisure activities, how it's impacting on their general life, their general well-being. The carers' assessment is a component of the assessment of the disabled person, because having worked out that the carer isn't perhaps willing to provide as much care as they have been, perhaps having worked out that the carer is suffering considerable stress and anxiety, having worked out that the carer is actually in work and so needs to be sustained in work, we then look at the disabled person when we decide how their eligible needs must be met. There is one very important point that we have to understand when we assess disabled people, elderly people, ill people, is that when we're doing that assessment, we ignore completely the care that they are getting from family, friends and unpaid carers. We look at them as if they were on their own and we say, what would happen to them if they didn't have support? We ignore the existing support that they're getting. Often, therefore, with somebody with significant disabilities, the answer is that they'll die if they don't have support. We then ask the carer whether they're willing and able to continue providing that care. And if they are, then that element is included in the care and support plan, and that's something that we'll be looking at in this separate talk on that subject. In the resources and materials pack that accompany this talk, we have a lot of materials that deal with commonly occurring problems and ways you can address those problems, precedent letters for challenging difficulties. But in this part of the talk, I'd like to look at three particular problems that occur. The first is delay, where local authorities don't carry out assessments or carers assessments with due diligence and speed. The second is where local authorities have very rigid criteria, where they say, well, we just don't do this or we just don't do that. And the third concerns something called funding panels or allocation panels or just panels, whereby a local authority social worker or social services officer may have decided that you have an eligible need for something or other, but then a senior officer or a group of officers, what's sometimes called a panel, make a decision that you don't need that. They overturn that, or they do something to that decision that waters it down. None of these statutes that deal with assessments lay down a timescale for how quickly they should be done. There's a general legal principle that says that where that situation occurs, where the statute doesn't lay down a timescale, then the law requires the activity be done within a reasonable period of time. And that may seem innocuous and unhelpful, but it's not. What would happen is that the court or an ombudsman would say, what is a reasonable period of time in this particular situation? If the assessment is a simple one and the need is quite obvious, then of course a reasonable period of time will be short. Whereas if it is a complex assessment involving lots of different professionals and requiring lots of different conversations and discussions and perhaps reports, then of course the timescale will inevitably be longer. An assessment must be as quick as possible and it must go into the necessary detail. That's not always huge detail because, as I've said, sometimes needs may be quite straightforward. As a general rule, the Ombudsman has said that a community care assessment should be undertaken and completed within 4 to 6 weeks. Now that will also, of course, include a carer's assessment because a carer's assessment is part of the overall assessment of an adult. There is guidance issued in England and Wales suggesting that timescales for the assessment of disabled children. And again, those timescales indicate that straightforward initial assessments should be done speedily, perhaps within a week. But the more in-depth, what are sometimes called core assessments, should take longer, perhaps up to 7 weeks. Now, there will be many community care assessments, social care assessments, carers assessments that take longer than 7 weeks. The requirement is that the local authority explain why that is happening, and if anybody believes that there is unnecessary delay, then they will have to make representations, make a complaint, and those materials are accompanying this talk. On some occasions, local authorities will say that they have a waiting list for assessments. Now, if the waiting list is a matter of 1 or 2 or 3 or 4 days, then that may be acceptable. But a general approach to waiting lists is, the court's general approach to waiting lists is that those are unlawful. Local authorities must undertake assessments without delay, and if there is evidence of waiting lists, that means that the local authority isn't properly resourcing this obligation. On some occasions, local authorities might say, well, we can't do a carers assessment until 3 or 4 months' time, and in that situation, a complaint must be made immediately. A second commonly occurring problem is what I call rigid rules or rigid policies. not infrequently, a social services officer or somebody from the council will say, well, we don't do that. We don't do respite care at an evening or a weekend. We don't provide grants over £200. We don't do home help unless there's some other need. We won't do housework only and things like this. Now, at law, those are all generally referred to as a fettering of a discretion. If Parliament has given a local authority wide powers, and it has given them very wide powers indeed, then local authorities don't have to use those powers. But the one thing they can't do is to say they'll never use them. That's called fettering of discretion. Now, if Parliament wanted to say you can't use your powers to assess children with attention deficit hyperactive disorder, then Parliament would have said that. Since Parliament hasn't said that, a local authority couldn't have a rigid policy saying that it will never do such an assessment or it will never provide respite care in a day centre, or it will never do something or other. It's very important if somebody is told that this particular local authority just doesn't do a particular activity or doesn't undertake a particular type of assessment or won't make a payment beyond a certain figure, that they get that in writing. Now, in the resources and materials section at the end of this talk, we have some precedent letters that can help people do that, because in general a rigid policy is one that is unlawful. The final commonly occurring problem I'd like to just mention briefly it concerns things called panels, allocation panels, funding panels. Now again, at the end of this talk in the materials and resources pack, we have a specific item concerning panels, but I just want to mention briefly what they are and why they are problematic. At law, an assessment should be carried out by somebody who's a professional who has the expertise and understanding of needs, and she or he will come to our house and will look at all the situations and gather all the relevant information. And as I've already said, 75% of that information may be visual, what that person sees. They'll go back and then make a decision about which of those needs are eligible and which are not. Not infrequently, however, that decision will be challenged by his or her senior manager, or will have to go for approval to a panel, a funding panel. And very commonly, the senior manager or the funding panel will say, no, we're not going to meet that need, or we're not going to meet that need so generously, cut the package. Now, what the courts and the Ombudsman say is, well, what is this panel doing? Because this panel hasn't seen the person. This panel hasn't been there, hasn't taken into account all the relevant information. This panel or manager may not know the person at all. What discretion do they have to bring to bear on this question? The social services officer has been the one that's been there, done these things. This is the person who's trained. And so how can it be that somebody that doesn't know anything about this is overruling this? And of course, the reason it's being overruled or it's being trimmed, the package is being trimmed, is because of cost. The law is clear. Need must be met if it's eligible. And in deciding something is eligible or not, cost is not a relevant factor. So very frequently, if you're told that although the social worker or the social services officer thinks that something is an eligible need, it's quite possible that the panel will overrule it, then again, you should look at the resources and materials pack at the end of this talk and the specific paper we have on panels, and also this should be challenged. In this final section of the talk, we make reference to further resources and materials that you can use to go into the questions in more detail. It includes precedent letters and articles and books. There are books that can be downloaded free from the internet. which have sort of the wicked detail of the problems that you might encounter. And you're now going to see a slide in which some of these materials are listed. I hope that this talk on the assessment process, which is one of a series of lectures we're doing on the social care lecture series, has been of help. I hope also that the materials listed at the end of the talk will enable you to answer any remaining questions you have.